Good morning, everyone. I would like to extend a very warm welcome to Mr. AUH Sharma, Advocate on Record Supreme Court and Managing Partner at MS Law Partners, Major General P.K. Sharma, Professor and Director, Amity Law School and Dean Faculty of Law, and fellow faculty members present here today. Socrates once said, "Let the questions be the curriculum." Curriculum development is the standard item on the agenda of university boards and their faculties. There are several sources of pressure to keep the curriculum developing, many of which are external to the academic group, including the need to compete in the market for home and overseas students, government expectations, emergence of new technologies, employers, professional bodies, and accrediting institutions, industry, and the professions. In the area of intellectual property education, the pressure for curriculum change comes from a similar range of stakeholders and similar circumstances. However, it is important from an early stage in any discussion of curriculum change in the area of intellectual property to be prepared to consider the subject both as a law discipline and as an interdisciplinary subject. The intellectual property rights curriculum in universities is in a constant state of development, given the continuing development of national and international intellectual property rights. Universities are also looking to design intellectual property programs that are relevant to business, the creative industries, science, and technology. At the same time, faculties of diverse disciplines, including business, science, applied sciences, arts and humanities, are themselves beginning to appreciate that intellectual property should feature on their curriculum. The topic for today's session is developing research-oriented curricula to enhance availability and applicability of intellectual property rights. Mr. AUH Sharma is an advocate on record Supreme Court, managing partner at MS Law Partners, a registered patent and trademark attorney with 17 years of experience in litigation and ancillary services. He is an active litigator, having appeared before the Supreme Court of India, High Courts, and various tribunals such as NCLAT, NCLT, TESTAT, and NCDRC. Mr. Sharma has also represented clients before investigating agencies such as CBI, ED, and EOW in investigations under the Prevention of Corruption Act and the Prevention of Money Laundering Act. Mr. Sharma conducts due diligence of intellectual property portfolios of organizations in various sectors such as medical equipment, renewable energy, automobiles, pharmaceuticals, etc. He also provides freedom to operate, infringement and invalidity opinions apart from advising clients on licensing and intellectual property management. He has extensive experience in drafting and negotiating contracts, litigating disputes in content-driven industry and intellectual property. He has worked on various production contracts, recording contracts, artist management deals, model management contracts, agreements for licensing of TV shows and animated series, opinions on regulatory matters, and sponsorship contracts. May I now request Mr. AUH Sharma to address the gathering. Participants are advised to ask their questions using the chat.
Good morning, everyone. First of all, I thank you to Amity University and Major General P.K. Sharma to give me this opportunity to share my thoughts on aspects of curricula which may be required to enhance the IP availability in universities. Okay. Because when Mr. Sharma spoke to me with respect to this topic, we realized that there are certain things which are not in line with the practical aspects, maybe in courts, maybe in agreements when we discuss, or maybe specific rights of under copyrights, patent, trademarks. Because what even me, because I have 17 years of experience, when we went through IP courses, it was more from the aspects of theoretical. What is patent law? What is copyright law? What is trademark law? But when we came out in the field, and especially in the litigation, then we realize that there is a drastic need of change in the curricula. So especially teachers can tell their students that what can they expect in the field of litigation, in the field of contract drafting, in the field of contract negotiations, because a lot of times there are new emerging technologies, new emerging laws, even the laws are being changed every day, especially, I can talk about from Delhi High Court. If you see almost once in a week or once in 10 days, there's a new landmark judgment from Delhi High Court with respect to the IP law and how the IP is being perceived and done in the practicality. So, Mr. Sharma, told me to share my thoughts because I may have some better practical knowledge since being in industry in the last 17 years and doing litigation day in and day out, apart from contract negotiations. So I'll share my screen now, and then I will talk about certain things which may be required to develop into curriculum. Although I know and I believe that there are certain regulations and the guidelines which every teacher has to follow with respect to the course curricula prescribed by the universities, prescribed by other institutions. But there are certain things which according to me, teachers can tweak and teachers can look into from the perspective of more practical aspects. So when a student comes into a practical field, he or she may have a better understanding of IP, how they can use IP in day-to-day life, because a lot of times even lawyers are not sure what can be trademarked, what can be patented, or what can be copyrighted. It's all theoretical, but when we sit down in practice and discuss and do and perform the litigation, then we see the difference between, okay, fine, this can be patented but not designed, this can be designed but not patented. Sometimes a theoretical knowledge may not be sufficient. So I'll just after my basic thoughts, I'll share my PPT and then I'll discuss certain things about it. Please give me a second. So I hope my PPT is been everyone can look into it. So that
Yes.
this is the topic:
Yes.
developing research-oriented curricula to enhance availability and applicability of intellectual property rights. Now, why this is very important to talk about with respect to developing research-oriented curricula? Because just give me a sec. Yeah. If from day one, we design a specific kind of curriculum for students, so that students are equipped with a strong understanding of IPR, but also they can understand how these concepts, how these knowledge can be used in day-to-day activity, how can this knowledge can be used to solve the issues of the clients, because there are certain kind of issues which I have also come across, that which I've never thought about in during when we were in college. We have never realized, okay, fine, this could be an issue, these minor issues could be a big problem and bone of contention for a landmark judgment a court has to come. A very basic example I'll talk about, jurisdiction, where a case can be filed. Now, if we only talk about theoretical in our curricula, we don't talk about practicality, like what happened. I'll discuss with infringement later, but let's say if there is an infringement, how and where you will initiate an action. Now, if a person who is going into practical field, who is going into litigation, if that person is not sure about how to take an action, where to take an action, he may not be able to solve the issues of the clients. So that's why, apart from theoretical, apart from strong understanding of IPR, we need to develop a curricula which at least give a basic practical information or knowledge to students so they can use it. Now, first of all, we have to understand what is our target audience. The every teacher has to look into it. Now, this is basically more relevant for a post-graduation student curriculums, because when an undergraduate, a student coming into a college, he's basically 12th, in 5 year law courses, he has all completed his 12th. He may have a science background, a commerce background. A lot of colleges or universities, are not really concerned about deep information about patents, because you need to have a strong technical background. So, but for students coming into postgrads, the students could be from the business side, could be from engineering, could be from a lawyer, or could be from a science. So we have to see, especially in the postgrad, what are your target audience? Who are your students? What is the background of the students? Or maybe, you design certain kind of IPR courses for science graduate or for business graduate, because the business students will not have strong understanding of technology, so they may not be looking very much into patent law. They might need some basic information about patents, but not deep information, knowledge about how a patent can be drafted, how a patent can be prosecuted, because they somehow lack information on the knowledge on the science. But if a science student wants to do a postgrad in IPR, he may want to become a patent agent, and he may want to know how a patent specification can be drafted, what are the different type of patent specifications, how a claims can be drafted, or how a patent application has to be prosecuted. So while devising your curricula, you need to understand, you need to look into it, who will be your students. Now, after understanding who will be your students, you need to devise a specific learning objectives for curriculum. Now, that curriculum needs to cover all kind of theoretical knowledge, practical applications, and research skill development. And after research skill development, you need to uh, you know tell your students that apart from practical applications, you need to have a basic research oriented skills, because that will impact your litigation, that will impact your corporate drafting, that will impact your negotiations. Because if your research skills are developed in college itself, then you may know how a law can be used to draft a contract, how a law can be used to draft a licensing agreement or an assignment agreement, or when you're talking about joint ventures agreement, how the IP, intellectual property, has to devolve from one company to other company. A same research skills can be used to do a basic research for code drafting, how pleadings can be drafted, what case laws you need to present to the court. So apart from having a practical applications of practical knowledge, a teacher should emphasis also on research skill development of a student. Then obviously I'll come to what can be included in your curricula. First of all, in whether an undergrad or a postgrad, we need to start from a strong foundation of all kind of intellectual property rights, which will cover patents, which will cover trademark, copyright, designs, and trade secrets. Some people have no knowledge about trade secrets. Even the lawyers are not sure what a trade secret is, what is a confidential information, how can we use a confidential information. They think that trade secret or confidential information are a part of a contract drafting, so they are not concerned about IP. No, that is trade secret or confidential information are very important intellectual property. we need to inform our students about practical aspects of trade secret. I give you a basic example. Everyone knows in the world knows Coca-Cola. Now, the formula of Coca-Cola, how the Coca-Cola is being made, what are the ingredients of Coca-Cola is trade secret. No one knows the formula of Coca-Cola. You can Google it. No one knows. Even Google will not tell you what is the formula of Coca-Cola, how Coca-Cola has been made. And they are so secretive about the formula that only 2 or 3 top people knows where the formula is kept, and they don't travel together ever. So if so, they are so confident, so they are so they protect their formula as a trade secret. They have not patented it, they have not copyrighted it, nothing. They have just made it a trade secret. From day one they say that we will not tell anyone about our formula. So you have, and this is all trade secret. A lot of people will not realize, because they don't realize the value of trade secret, they may not use it in the practical aspects. When a company comes to us, we ask you, okay, fine, what do you want to do? Whether if, because in patents, whenever you file a patent application, it has to be published by the patent office. So it comes into public. So we ask whether you are okay with disclosing some kind of information to public or not. Once clients say, no, we are okay, we need a patent on technology, then we go ahead for the patent application. So we need to understand the foundation of all IPR and significance of each type of IPR, and also how an intellectual property can be used and what can be protected by a specific kind of intellectual property. Because sometimes when we are talking about logo or shape of a design, even the lawyers get confused whether the shape can be protected under Designs Act, or shape can be protected under Trademark Act, or how an artistic work can be protected under copyright. So we need to devise a curricula to inform our students, and so the students are sure about core concepts of intellectual property. Now, after the core concepts of intellectual property, we need to also talk about national and international frameworks of intellectual property. Now, because there is one big misconception among normal general public, that once a patent is filed, it gives you protection for all over the world, or there is something called a worldwide patent. No, we need to devise, or we need to inform our students, we need to emphasize, we need to tell them that all intellectual properties are territorial in nature, be it copyright, be it trademark, be it patents. So if we have a protection in India over a patent, it will not give you a right maybe in England, or maybe in USA, maybe in Europe. And at that juncture, international framework of intellectual property come into being. You have different mechanisms to file international patents, or maybe trademarks, or a copyright. You have Madrid Protocol for protection of trademark. You have Berne Convention applications for copyright. You have WIPO, which takes care of patents and other kind of IP. You have Patent Corporation Treaty, PCT applications for patents. So apart from national framework, we need to inform our students that since intellectual property is territorial in nature, we must know what are the international frameworks. Now, talking about national framework, we also need to discuss, or we can discuss about what government is doing with respect to protection of intellectual property in India. Like we have national IP policy. So that is very important. The national IP policy can be discussed for students who are more into research oriented, that they want to maybe perform their PhDs in IPR, or they want to become teachers like you in IPR. The information about national IP policy may be relevant. So we have to cover not only Indian laws like Patent Act, Trademarks Act, copyright, we also have to discuss about international frameworks and also about information like IP policy, what is happening in India, how the intellectual property has been developed in last 20 years, 25 years, since because the Patents Act was enacted in 1970. We are in 2023. That's almost 53 years of a Patents Act. But when we see the information about Patents Act is not much in India. Every lawyer or every teacher only, I've seen they talk about Trademarks Act or a Copyright Act. Even the lawyers are not sure about Designs Act. So apart from and how a design can be protected or how an IP can be protected in foreign countries, we have to tell everyone that there's nothing like worldwide patent or worldwide trademark or worldwide copyright. Now, we can also devise research methodologies with respect to IPR, like how a trademark is being searched. Like if a student comes to you and say, I want to trademark, let's say Amity, and we are not sure about whether that can be trademarked or not in a specific class, you need to tell them this is a way you can search a trademark application or a mark on an Indian Patent Office website. Now this is a mark. All such information, be it patents or copyright, trademark or design, basic information can be searched on Intellectual Property Office's website, which is ipindia.gov.in. You can search under specific class, you can search with a specific patent or a technology or a company's name. So, and that will help a student to understand how and where his skills can be used, because a lot of time client comes to us and say, okay, we want to file this trademark. So first of all, we perform a basic search whether the trademark is being filed by somebody in that specific class or not. If it is, we inform our client, okay, fine, this is not possible. If not, then we inform a client, okay, fine, this is possible. So this is all our research skills which we have developed over a period of time, looking into websites, looking and understanding a lot of things. Because when we passed out, I passed out in 2006. When we passed out, all these informations was not readily available. Even the IP office websites was totally different what we have right now. We have much more information publicly, freely available. It's just freely available. You don't have to pay anything on a IP office website. Your students can just sit, understand how a trademark, if you just file, if you have an application number, just search for it, see how an application is being filed, how a responses has been filed. We get learn to see, okay, fine, this is a way a specific kind of reply has been filed by somebody, or this is a way a specific kind of an application has been filed. And do you know that in India, I don't know, how many of aware of Yahoo email? It's very old email. Now, the sound of Yahoo is being trademarked in India. So under the category of sound mark. So which even when we passed out, it was not there. It came over a period of time. The law has evolved, and all these things are available. If you talk about India, then you have Indian Patent Office website. If we talk about WIPO, the WIPO has its own website where things can be looked into. Then for trademarks, we have niche classification where you can search for goods and specifications or services. So these are and all these things are freely available. So we must tell our students, fine, go on these websites, spend some time, do some searches, understand how things are being filed, how marks are being filed, how, what kind of shapes are being filed as a design applications, what are the formats, because everything, even the patent specification is freely available. So they can go on the patent office website, do some search, see how a patent application is being drafted. And so they will learn from day one how these things can be used in practical field. Then obviously, after all these research, we must tell our clients about case studies, how an IP is being used in day-to-day activity. The one of the example which I took is a Coca-Cola. You can discuss the example of Coca-Cola. Then you we can discuss examples of IBM. Now I now the why I'm taking example of IBM is that IBM, when you join IBM tell their employees, fine, apart from your regular work, your performance is all will also dependent on the number of patent which you have filed. So if you see, just you leave last year 2022, but till 2024, for at least for a period of 12 years, IBM was the largest filer of patent applications in United States. Why? Because their strategy is they want to protect anything and everything what they can do. So they can license their patents, they can assign their patents, they can make money from the patents. So apart from the servers, big servers, or chips which IBM make, if you do a Google search, you will realize that IBM makes a lot of money only by licensing their intellectual property, nothing else. That is a one big revenue model of IBM. So we need to discuss such kinds of examples with students, so students know that actually IPR can be used to generate revenue. Because at the end of the day, why we or clients want to file or want to protect their intellectual property? Because one, they want to protect they want to make their own brand. Second is they want to make more money. It's revenue. Because you take an example of Nestle, you take an example of any FMCG code or Maruti or anything. So they are very critical for their IP protection, because they have developed their brand. They want to, if let's say Maruti Suzuki, it's a collaboration of an Indian company and a Japanese company. So when Maruti entered into an agreement with Maruti Suzuki, so they have discussed their IP rights, what actually and how actually Maruti's trademark will be used with the trademark of Suzuki, and how the revenue sharing model can be done. So these kinds of examples will enhance students' minds to think about practical use of intellectual property in open field. Now, one one big format which I always believe in, this is that an IPR student should discuss or work with students of a different field. Because we have our own IP patents team. So when client comes to us saying that we want to file patents, so first of all, especially for Indian clients, a lot of Indian clients, we have to tell them that what is patent, what can be patented, how things can be patented, what all things can be patented. So and there are brilliant engineers working in the field from last 20 years, last from 25 years. They are performing, they are just doing one small activity, performing their task to perfectionist, but they don't know how to protect their IP. There are people who are only working with batteries. There are people who are only working with tires, but they don't know how to protect their intellectual property or what can be protected, because maybe they were never taught about it. No one discussed it. Maybe even 20 years back, the IP was not so prevalent that no one thought to protect their IP. So when a IP student or a law student having IP background sits with an engineering students and from day one, from their graduation time, if an engineering student is being made well aware about the intellectual property, especially I'm talking about patents, that okay, fine, this can be patented. Like let's say even law is developing, but a couple of years back, softwares were not allowed to be patented in India. In a different format now, yes, they can be patented. But now that is obviously a legal aspect how it can be patented. But from the other engineerings, they were also not sure about, okay, fine, this this can be patented, this cannot be patented. And well, now after having basic understanding of intellectual property or a patents, I believe every engineer thinks that everything can be patented. That is also not possible. So they need to, the engineering students need to need to work with law students, how a technology can be protected, what can be protected. So if they have knowledge from their college time, they can be a good resource for the companies in future. They can tell the companies in, while sitting in their interviews, fine, I have basic understanding of intellectual property, or I have filed couple of patents in my name, or I know what can be patented. So engineering companies or technology companies will, will be well equipped to hire them, because they don't have to teach them. They think, okay, fine, he's a good resource, he can help them in protecting their IP. Also, such kind of interdisciplinary approach is, according to me, is required between law students and especially from the engineering students. Now, apart from all these things, we need to discuss with students about practical training. One way of a practical training is internships in IP law firms, where they can learn maybe how a code functions, how a trademark suit has been filed, how a patent has been drafted, depending on in which field they are working. Then they may be, apart from internships in IP law firms, they may be taught, or the curricula is being developed where a teachers or a lawyers can be called upon to discuss more about practical aspects of IP. I'll discuss a couple of things now, but now the hands-on experience, if we talk about a person who is litigating for 10 years, 12 years, 15 years in an intellectual property, he may have some kind of an information of or a practical experience which will help the students to understand, okay, fine, how things are being done. Now, couple of topics which I want to discuss on the practical training that which can be looked into. That is, one is how an IP is being enforced and how it can be litigated. Now, this topic involves the understanding of enforcement mechanism available to protect intellectual property. Now, a teacher must tell their students that apart from civil, all apart from copyright, patent, trademarks, designs, all are civil nature of cases. In copyrights, you can even file a criminal case for theft of copyright or a violation of copyright. There is a provision, and then there are case laws being discussed by Bombay High Court or Delhi High Court, whether the case which has been filed under Copyrights Act, whether that is a bailable offense or a non-bailable offense, things have gone up to that extent. And apart from what kind of remedies for a violation of an intellectual property, we also need to understand where that case has to be filed, because there are certain changes between Patents Act, Copyrights Act, and Trademarks Act. Unlike, because we all know Civil Procedure Code at that section 20 of CPC, that a case has to be filed as per section 20 of CPC. But there are certain exceptions, or I say additional forums which is given under Trademarks and Copyrights Act, wherein your section 20 may not be available, but other places, that is where the person resides. Now, as per CPC, if I want to file a case, I have to go to a defendant's jurisdiction where the defendant is residing. It's a normal CPC. I'm talking about civil. But under trademarks and a copyright act, I can file a case at my own jurisdiction. I don't have to go to a place where the defendant is arising or where the infringement is being taking place. That's how we need to devise a curricula to inform our students that apart from these normal civil and criminal remedies, there are ways, different ways how and where to initiate an action. Now, before, a lot of times what we advise our clients that before initiating any action, let's try to solve the problem, directly with the other side. So what we do, we send a cease and desist letters, or cease and desist notices saying that you are infringing our mark, infringing our patents, infringing copyright, and we believe that, if you are able to stop it, we can solve the issues. If not, then we may have to go and file a case in court. Sometimes these are very effective notices. A lot of because a lot of times even the other side is not aware of a mark, or is not aware of a patent, or is not aware of a copyright. So when they realize that they are infringing somebody else's trademark or somebody else's copyright, they obviously, no one likes to go to court. So they may say, come back and say, okay, fine, we will not do it again, or this is the cost which we have incurred, or something like that. So we negotiate on table after. Sometimes, I'm not saying this happened, but this is an effective way of negotiating and finishing a litigation even before it starts. Sometimes, obviously, some are habitual infringers, so they are not worried about such cease and desist notices. They say, okay, fine, do whatever, we will perform whatever what we are performing. Or then obviously, then we proceed to a next section and file a case, maybe a trademark case or a patents or a copyright LD. But yes, and there are different formats for cease and desist letters which can be discussed, or notices which can be discussed. How a cease and desist notice can be drafted, what can be involved, or what can be covered into those things. Then we have alternate dispute resolution, such as arbitration. Now, there are certain judgments, especially one came in 2021 by Supreme Court, where that intellectual property disputes can also be arbitrable. You don't have to go to court for every intellectual property dispute. If there is an agreement between two parties, two companies, and then there is some dispute arising out from that agreement which relates to intellectual property, that can be arbitrable. So, and obviously, and now under Arbitration Act, the government has, devised a time limit for expedition of arbitration, that within 1.5 years, you have to complete the arbitration. Obviously, you may know that once we go to court, if the other side, wants to litigate a civil case in India, which will take about 3 to 4 years, but an arbitration can be completed in much before. And it's a proper kind of a suit where you file your evidences, where you take all the legal arguments, and it's a final decree like a CPC, like a civil court, and which can be finished within 1.5 years, much before a civil suit. So there are ways to. One is arbitration. Obviously, if an agreement provides for an arbitration, then there are court-appointed mediators which go into mediation. Now, Government of India, to reduce the litigation, have come up, a mediation process that even for every commercial suit, you have to pre-litigation mediation. You have to perform pre-litigation mediation, which is necessary. If you don't do it, your commercial suit can be dismissed. So, and these mediations are being performed by court-appointed mediators, so they know what they are doing. So, laws have been evolved by the government to reduce the litigation, to bring more alternative dispute resolution, so clients or parties can finish or can reduce the litigation or can complete the issues much before, and which is obviously less costly compared to litigation. Then obviously litigation I've talked about. Then once you file a litigation, then there are certain kind of damages and remedies which you can ask for. Now I come to contracts, which is because a lot of lawyers obviously will not go into litigation. They say, okay, fine, we are not equipped or we don't have patience in for litigation. We are more interested into contract drafting or negotiating with clients. So, and there are certain kind of clients, because a lot of companies don't realize that employment agreement is a very important agreement, because sometimes there is the clause of intellectual property under employment agreements is not there. So whatever employee has made, it goes with the employee and the company is stuck. So what we tell our clients that in every employment agreement, you need to have an IP assignment clause that whatever employee is making, that will go to the employer automatically. Then obviously we have NDAs, non-disclosure agreement, when we are dealing with a technology and we are entering into joint venture agreements. Then IP license and assignment agreement, which I have talked about. IBM, what IBM is doing, they are making a lot of money from IP licensing or a technology transfer agreements. So even if we are just dealing, for an example, I am a manufacturer of a good and I am giving that good to a distributor to, for a specific area. I may have to protect a trademark. I may have to include a clauses saying that the distributor cannot use my mark in any other way. Or after once the agreement is over between the parties, he may not use it. So, and sometimes, a lot of, these such kind of clauses are not there in the agreements. So apart from agreements, contract is also a way to protect your IP, and all those alternative dispute mechanisms comes from these contracts. And arbitration, there has to be an arbitration clause under a contract, only then you can arbitrate. So contract drafting, a type of contract drafting, what can be protected, how IP is protected. Sometimes IP is being just licensed for a specific area, IP is being assigned completely. It may be an exclusive license, non-exclusive license. So we have to look into such kind of practical aspects, and we have to inform or teach our clients how even the contracts can be used to protect the IP. So these were the examples I've taken for the practical aspects. Then you have, guest lectures and industry tie-ups, which obviously I have discussed. Like for a litigation, you can you can call any litigator who is in IP field to share his thoughts, which we can specifically how an IP is being litigated. Or you may call up tie up with an in-house counsel of a big company, so they can tell the students how they are protecting their IP in-house, what are the mechanisms they are using to tell their employees to protect the IPs. So such kind of guest lectures and industry tie-ups are also very important. And then obviously internships. So I have spoke about that internships can be in a law firm, or internships can be in a in-house department of a big or of a company, where they can learn about, apart from normal general contract work, they can learn about how an IP is being protected. Then you have ethical considerations, because a lot of times, and what we see, a lot, sometimes, I'm not saying all, but sometimes a student, during their dissertation, during their projects, they try to copy somebody else's project, or they take information from Google, put it in their project without giving due remarks or consideration, and they project it as it their own. Now, because internet is there, anyone can access anything, and even there's a huge chunk of information provided. Whatever project you may give it to your students or a dissertation, there will be some information. So we have to tell our clients that they cannot simply copy the information from internet. If they are using some kind of an information, or if they are using some kind of journal, they have to give complete consideration in their dissertation, like let's say footnote, like one paragraph they have copied from somebody's book, then they have to give complete information about that book. Okay, fine, this is a book, writer, page number, so they know. So you also know, and they also know that they are applying their mind, not copying. Because once you give due consideration to that book, it means that you are not copying it, you are not showing it as your work. Because sometimes what happens, you have to rely on some case laws, then you have to give citation of the case laws. You cannot say, oh, it is there, it is your mind, and something like that. So the students, I know it's difficult for teachers to look into each and every piracy case, or copyright case, but there is a way a teachers can inform their students, okay, fine, that this is wrong, this is not ethical, you cannot copy somebody else's work and give it to me, because that is not helpful for students in long run. If the students are copying, once they go into field, they will not be able to apply their own mind. This is a way to give an importance of others intellectual property. Then then we what we as this is especially for engineering students, what we tell as teachers, that you link IPR to innovation uh, and to companies. Because if you see a lot of Indian startups, which talks about, okay, fine, most of the Indian startups relates to service industry, but some of the Indian startups relate to technology, and they uh, just work on their technology, develop their technology, and build their empire. Although it's a old case, I have a client, about 10-12 years back. At that point of time, they were startup. They filed one patent in India and in US. I helped them. And on the basis of that patented technology, they were able to raise funds. And thankfully now they are one of the biggest market in their field, although it took some time. But because of that patented technology, they were able to raise funds from industry, because industry realized that there is something good about their product, good about their technology, which can be protected, which can be used in a certain kind of a way. And they were able to sell their technology also to market that, okay, fine, this is the technology, we can perform these many tasks with this technology. So you have to you know inform or teach the clients that IPR can be used to generate revenue, and how IPR can be used to innovate. And when the law students or IP students talk to their friends in the science form or a medicinal side, they can tell them, okay, fine, this is a way you can protect your IP. Because now if you see, a lot of universities are collaborating with students in filing a patent applications. So you have university, you have your professor or vice chancellor, whoever from the university, and the second inventor is a student. So the student, but this has to be start from the student. A student has to come to the professor and say that I have this idea which can be protected, I have this technology which can be protected. But if the student is not aware of the IP protection or how an IP is being protected, they may never go to their teachers and say, sir, this is something which I think can be protected. And the professor or their lab teacher can think, okay, fine, let's see, let's discuss whether it can be protected or not. And that's how students are being taught to inculcate the inventive ideas, and how students can help even the universities in protecting some IP. It's like vice versa. Teachers teach students, students come up with their ideas which can be protected along with the universities. And now, I think Indian government has come up with a marking or a ranking, where they see how many patents have been filed by a engineering college or a medical college or institute, and on the basis of that also they mark or they rank it. I suppose that is also done by the Indian government to promote an intellectual property. Then research projects obviously, you have different kind of a new technologies or new IP laws coming up wherein much information is not there. Let's say artificial intelligence is one topic which is being discussed all over the world. Now if you see, there are a lot of countries which have granted patents wherein artificial intelligence is an inventor of a technology. Some of the countries have refused to grant such protection, saying that only living being can be an inventor of patents. So such kind of new topics, what will happen, whether in India over a period of time, artificial intelligence can be regarded as an inventor or something like that. There are new topics which are coming up which teachers can uh, ask their students, not only the theoretical subjects or theoretical topics, but the topics which have some practical utility. So that kind of research projects can be given by teachers to the students. And then obviously, I don't have to talk about updates and the feedbacks which teachers will take from the students, because that is also very important, whether even the curricula which is being taught to the students, whether that is beneficial to them, or whether what the students think, whether this is more of a theoretical or a much more practical. They are not being taught about core concepts of IPR, only practical things. I mean, so that kind of update and feedback you must have it from your students while teaching them, while devising a curriculum, not by devising a curriculum, but teaching them during your semester, or what changes they think, because they may have certain ideas which you can incorporate for next semester and all. And also you can discuss with industry professionals or academics or from a different field how to improve the programs. Then I think I'm about to close my PPT in maybe in a couple of slides more. Then obviously promote awareness. I've during this presentation, I've talked about how how a student can be taught about IP. So awareness is very important. If students or a general public, is being made known about their IP rights in a day-to-day activity, that will help this industry, that will help this country and everyone. And then obviously there is an assessment which teachers have to do on their research topics, on their practical exams, on their mood codes. You can also devise one point which I missed in this PPT, the mood code, wherein you can give IP related issues as a mood code, where the students can make their present their cases, and and teachers can evaluate on their arguing skills also, because a mood code can take care of both your research skills also and your arguing skills also. A mood code is also very important, which you can devise in your curriculum. Then obviously emerging issues in IP, as I have talked about, artificial intelligence and IP is the topic right now in the whole world, which everyone is talking about. Then in India, laws are being developed for software patents, how a software can be patented. Every day, some or the other high court is coming up with a judgment or an interpretation of a software patents and all. Then I have already talked about this in an international framework of IP laws of a WIPO treaties, TRIP treaties, Madrid Protocol, Bern Convention. This has to be discussed with the students to so they know how IP has to be protected in a different parts of the world. Because even now, a lot of companies come and say, I want to file a worldwide patent. There's nothing like worldwide patent. You have to protect IP in specific territory. Then IP strategies and management, that is more for a students who are looking into business side of a intellectual property, or who wants to go in-house, or who wants to perform some business, how an IP can be protected, what are the strategies, whether you need a strategy like Coca-Cola, or you need a strategy like IBM, or you need a totally different kind of a strategy because your product is very different. So you need to discuss different kind of strategies for a different kind of product among students. You can give a project, fine, this is a project. Now devise a strategy, how to protect this product, in an intellectual property way, and then and then students can discuss their own strategy. Okay, fine, this could be better, this could be better. Pros and cons of each strategy can be discussed with students. So students know, especially students coming from business side and going into postgrad, they may know how a business can be developed over an IP. I think I finish. Actually, I pause my presentation here. I'll see if there are some questions and then we can discuss it further. I'll stop sharing. There are some, I think there are some questions on the chat.
We will ask Toshi. Toshi can ask the questions which have come in the chat box.
All right. So the first question that has been put up is by Ms. Ashamina. She is an assistant professor here. She's asking, how can research-oriented curricula address the ethical considerations related to intellectual property rights?
See, research-oriented curricula must have an examples or a way to inform the students that what is right, what is wrong. Because there may be some case laws, there may be some examples which we can talk about. I'll give a very big example. I think most of us are not aware of it. There is a provision called section 3D in the Indian Patents Act, which talks about how a pharma product can be patented. Now in 2005, when India joined TRIPS agreement, there was one Marshall committee was appointed to devise the strategy or how a 3D can be protected. There were some issues with respect to that Marshall committee report. There was one student. Now he became a professor, Mr. Shamnath Bashir. Tragically, he passed away a couple of years back. He said that they have copied a certain part of their report from his thesis. And it became a hue and cry in 2005-2006, because you think about a government organization copying, a part of a thesis from somebody else. You have to give such examples to students. Say that even if you may be in a government organization, or maybe the information is like that, I'll say Google is like that, where anybody can find anything on Google. And now there are certain kind of say websites wherein if a student gives you let's say an article, you paste that article, that search engine will tell you which part of an article is being copied from where. So these kind of things have to be taught to students that this is wrong, and this will also cause them issues, because somebody can file a copyright infringement case against them or copyright piracy case against them. So we have to develop such kind of a curricula wherein you tell the students to apply their mind. You have to devise certain kind of formulas or strategies wherein you, during classes, when I was talking about IP strategies and all, certain kind of questions or a framework has to be developed by teachers during courses which force students to think from their own mind, apply their mind to use in a practical field or something field, so they don't copy. They, from day one, they say, okay, I don't want to copy, I want to apply my mind, I want to make something on my own. So certain kind of formulas have to be devised by students or by teachers. Sorry.
So we have a next question from Dr. Atul Jain. He's asking how IP education is responding to changing demands from within the law school and across the discipline.
Like I have discussed for the interdisciplinary approach, wherein a law student or especially an IP student can sit with the engineering student and sit down and tell them how an IP can be used to innovate, to develop something new. Then a lot of times, like there is an interplay of IP law and a CPC when you want to file an infringement case. There is an interplay of CRPC and IP law when you want to file a criminal case under Copyright Act, which a lot of times, let's say I'll take an example of if you talk to an IP lawyer about CRPC, how a criminal case is being filed, he may not know until and unless a student, IP student is being taught on different aspects of IP, how IP can be used, how, because now companies are going, very strongly against their own piracy cases. They say, okay, because everyone knows in civil cases, it will take some time and everyone want to file a criminal case. So they've put some pressure through other means on the infringer. So they stop copying their this IP. And other example, obviously, interdisciplinary with respect to technology and all.
So next question is from Dr. Monica Yadav. She's asking, do you think practical learning of intellectual property laws should be mandatory for all disciplines in the higher education institutes?
I think this is a very good question, and I believe that it has to be made mandatory for all disciplines. I'll say not even higher education, but I'm not saying for it has to start from class 12, because they should know what they, because copying starts from class 10, class 9, class 8. If, though it's not only for a higher education institutes or postgrads or a graduates, something like that. And a lot of times such things when taught to students or taught to different streams, they know how things are being developed. So I agree with Dr. Monica Yadav that this has to be made mandatory, if not detailed practical learning, but at least core concepts of IPR, what can be patented, what can be copyrighted, what can be trademarked, and basic concepts of it. I think it has to be taught to each and every college graduate, not even a law school, but college graduate.
So sorry, Toshi, I will just rather follow through with this question. Basically, why I was asking this was that, most of the people who are inventors, specifically when we come into the patent area, are people belonging to the science and the allied. That's where more of the patenting goes. So when I talk about the practical learning aspect, as an inventor, I, was trying to ask you that, how easy it is for you as a practitioner if your client knows that what is a claim, how a claim has to be filed, those kind of aspects. So if you could throw some light on that, because we do have some people from different fields other than law.
Okay, so when when a client comes to us for patent drafting, what we tell our client that he is the best judge about his invention, because he is the person who has made this invention. He knows all the integrities. What we can do, we can ask questions from him. So what we ask, the first thing is what we ask them to give us a technical technical write-up of their invention, what actually they have made, because they can explain in best way. Once we receive this technical write-up, then we go back to him and ask certain questions. Okay, fine, how you explain this, please explain this, please, because we are thinking from a legal angle how this can be protected. There the person has given what from the technical point of view, what and how, let's say if he has done some process, how a process can be achieved, certain steps of a process. We may ask more information. Okay, fine, let's say in this process, what are the ingredients we have used, what is the temperature, because we think how well a patent can be patented. So if a person knows that how a patent is being drafted, how a patent, what are the basic ingredients of a patent, even for him, it will be easy to make the technical write-up.
Right.
Otherwise, what sometimes, we see that they just make a PPT or like
Right.
two slides, 3 slides, and they send it to us, and we said, okay, fine, what is this? But if we discuss the same thing with a person who has already a knowledge, he will give a detailed write-up. So this practical learning, especially for engineers, is important. So when they discuss with their lawyers or with their counterparts or with their professors, they know what they're talking about. They know what to give information, what to hide, because in patenting, hiding information is also very important. You can't
Right.
disclose each and everything in your so
Right.
that is also an art to get a patent by not disclosing everything, so a person cannot copy exactly. There has to be something which is your proprietary. So obviously, if there are some examples or practical learning to, especially to engineers, they know what to discuss with the law. Sometimes there is a nothing against patent agent, but you will see that small startups or small inventors go to some patent agent. Patent agent says, okay, I will file your application, but I will put my name as inventor because you did not disclose me and everything. I have taken all this time to file this and we are amazed to see patent agents patent agent have filed some 10 application, 15 application, so they benefit from misinformation or a lack of information of inventors. So
Right.
kind of information is very important for practical knowledge is very important for students.
Thank you so much.
Ayush, our next question is from Sugato Mukherjee.
Yes.
He's asking, do you think that India's copyright law leans more towards protection of the creator's rights and does not give ample importance to public's interest in accessing works or the information contained in the works? If so, what are the modifications that the existing Indian legal framework demands in this regard?
When I am creating something, I want to reap the benefits of that work, be it patents, be it copyright, be it trademark. I have invested my time, money in, let's say, in writing a book or writing an article or making a PPT or anything. Now, let's say a book. A lot of times you see somebody else copy a part of a book, or somebody else a copy a design or a format of a website. For the person who's copying it, it's a matter of seconds. But for a person who's writing a book, it may be a couple of years. Some people, just write one book. They are able to just write one book or maybe 2 books or 3 books. It's their whole life and they make money. It's their own, this is a profession. I think Copyright Act is quietly apt towards creators, right? And I think this has to be the way in which Indian Copyright Act should work, because protection and reaping the revenue is very important. If you allow somebody to take the information, then there is no benefit or there is no zeal. There will not be a zeal for a person to work on their own to protect the IP, especially copyrights, because copyright is very literary work or artistic work is very easy to copy. Although there are ways in which public rights in accessing that information is being granted under Copyright Act, because if you see section 52 of Copyright Act, which talks about what is not a copyright infringement, there are exceptions, and it's not 1 or 2 exceptions. There are about 15-20 exceptions of a violation of a Copyright Act. You can take form away if you are writing your own, if you're using that information for your own opinion, if you are using that information to critique somebody, if you're using that information by giving a complete consideration in a footnote that cannot be copyright, or if you're copying a very small part of a work. So in Copyright Act, especially in Indian Copyright Act, we see substantial similarity. Whether the thing which you have copied is substantially similar to the original work. So public's right is well saved under Section 52 of Copyrights Act, because there has to be, I agree with you that there has to be a way forward for both kind of people, creators also and the people who want to use that information. You can use the information for a personal gain. You may not use that information for the commercial benefit. There are exceptions. So I think as of now, there is no need to change a Copyright Act. There are certain provisions which can help people in taking the information, in using the information in a certain kind of a way, which can be easily protected in the Section 52 of Copyrights Act. And there are obviously some case laws, like there are case laws coming up last month only with respect to the personality right of Mr. Sushant Singh has come up by Delhi High Court, which says that after he passed away, his personality right does not evolve or devolve into his legal heirs. So certain kind of laws are also being created by the case laws by different court. But I think there is the law is well equipped to take care of both the rights.
So the next question is from Mr. Parmod Tripathi. He's asking, spreading intellectual property law norms by using different propaganda like cinema, media, ad films, nukkad natak, etc. Will this increase creativity in India in the field of art, music, handicraft, scientific and other art form? Because in the population of creative people in India, there are lots of people who are uneducated. For example, folk singers, exploited by music directors of Bollywood. They use their creativity of music and earn millions, because these folk singers are unaware about their rights. Same thing happens in other fields, because creativity is not just limited to educated people.
No, I completely agree with Mr. Tripathi that the examples which he has given are can be used by different institutes or government to propagate the intellectual property laws. Now, apart from these things, I must say, if there are certain foreign TV shows which discuss about intellectual property. There are shows which deal with patents, which deal with copyrights, which deal with trademark and related aspects. There are movies. There is a movie, if you would see that for everyone, now it's very easy to see the wiper on the car, where you switch it on and the wiper can move automatically. But when wipers were manufactured or created, it was only created that if you switch it on, it will move on only once. Then you have to switch it on again, it will move it. So there was the automatic movement of wipers was not there. So a person has devised that automatic movement of the wipers. And it's a well documented history that all the big companies from Toyota, from GM, everyone copied his patent without his permission. And you see that there is a movie made on this subject. The Hollywood has made a movie only on this, how the big companies copied his patent and how he fought with all the companies and he won in the end, and the companies were forced to pay a huge amount of money to him. So such kind of, I'm giving just one example. If such kind of things, I agree, as Mr. Tripathi said, apart from cinemas, because obviously cinema is not, in reach for a lot of people in villages and all, a different kind of nukkad nataks, other kind of things can be taught, especially when we talk about geographical indications. The people who actually are working for geographical indication on a remote village have no experience about IP. They don't know what is IP. So if we tell them, okay, fine, this special kind of a product can be GI protected, and no one else from other can say that it is, let's say, Kashmiri silk. It's a very, vague example. But once it was started, people went to those people, say, okay, fine. If we talk about Kashmiri silk or a Kashmiri, saffron, if somebody is selling a saffron which is not, from Kashmir, they cannot call as a Kashmiri saffron. So such kind of information, yes, I agree with him, that has to be evolved by institutes or colleges or even by government. And because IP protection is must in today's world. Now we'll go to...
So our next question is from Dr. Vijaypal Singh. He's asking, how can research-oriented curricula contribute to the availability of IPRs?
See, I'll take both the questions. Mr. Ratnesh Kumar Pandey is also that IP awareness is very less in India, how it can be increased. I think these two questions are interlinked. See, we talk about research-oriented curricula, but we need to discuss what can be a part of that curriculum. We need to look into it. If a student is looking into his dissertation or his student is making a project, you can give a certain kind of topics to a student which will help them in towards the availability of intellectual property. You can give projects, internal projects which talks about core concepts of IPR, core availability of IPR. I agree that a dissertation may not be on a very basic topics. There has to be a very specific topic, but internal projects, internal curricula can be devised and have to be devised. That okay, fine, I want a person to understand the basics of intellectual property. To whom? To a person who is a science graduate, or to by a person who is a commerce graduate. So you devise a curricula, you think from a student's perspective that what is the information a science graduate is looking into when he is coming into an intellectual property course. He wants more information about core concepts of patents, core concepts of patent drafting, or other kind of thing. So you need, and there are a lot of information how a patent specification has to be drafted. People have written their thesis on type of complete specification or an example which can be included in the complete specification. What are the type of claims can be made? Either is a product claim, process claim, product by process claim. Even the law is being evolving. So you can ask a person to make a dissertation on product by process claim. This is a hot topic right now in India. There are a couple of cases where where the Delhi High Court has passed a judgment. You can ask a person to look into how a softwares can be patented in India, how a business method can be whether a business method can be patented in India or not. Now, if you see a couple of months back, Justice Pratibha Singh has given a recommendation to Indian government to change the law on business methods. How a business method has, because she says business method needs to be protected, but the law is not in favor right now. So Indian government should relook the law. And so she has looked into laws of different parts of the world. So that kind of an examples or that kind of a scenarios can be given to students to look into for their projects or for their dissertations. And how information, IP and awareness, as Mr. Tripathi has given an examples of IP awareness. I think Mr. Pandey's question has been very well answered by Mr. Tripathi's examples, what she is saying, like Nukkad Natak or cinemas or art movies and all.
We have two more questions, Ayush. The next is from Mr. Maruf Ansari. He's asking, for the promotion of research and IPR laws, the Ministry of Commerce and Industry has devised SPRIHA, which is Scheme for Pedagogy and Research in IPRs for Holistic Education and Academia. but the higher education institutes are ignorant to implement the scheme. Not only the development of research-oriented curricula relating to IPR laws, but we also need to produce ample faculty members trained in IPR laws. So do you think non-availability of trained faculty affects the standard of IPR legal education?
I completely agree with his question that non-availability of trained faculty affects the standard of IB legal education, and that's why Major General Sharma told me to talk about the practical aspects so teachers know what are the things which can be which can be brought into the curriculum. I think you must thank Mr. Sharma for bringing this topic for all these teachers so the teachers know from a practical aspects or how they can modify because they know a curricula. I'm not there to teach how to devise a curricula. I'm just saying what can be tweaked in that curriculums to include more information about IPR. So
How important do you think it would be that if there are practicing lawyers or practitioners of IP laws teaching law students or other students about IPR? Do you think that would be more relevant that if people who are already in the practice are also taking lectures?
I agree, but also those lectures will have to be only a guest lectures because a
Yes.
practitioner lawyer cannot come and
Yes.
teach.
Workshops.
Yeah, workshops. Like I remember, when we were in college, so our we used to work on Saturdays and Sundays. Our weekly off was on Wednesday, and so so obviously all the teachers asked the professor or Mr. Menal Mitra, who was the first vice chancellor, why? So he said lawyers will have time only on Saturdays and Sundays to teach the students. So if the students are off or on holidays on Saturday and Sundays, they will not have a practical aspects. So that's why now it obviously it's changed. But till my for 5 years, it was like Wednesday was our weekly off, and we used to work on Saturday, Sundays just because practitioners or industry people can come to us and give a guest lectures.
Our last question is from Dr. Vinod Kumar. He's asking, is there a difference between typical theory and actual practice of IPR? There must be industry-oriented lectures to fill this gap for better understanding and leaning among students and professionals.
See, it's not about only IPR. It's about, I believe in every field, there is a difference between theoretical and practical aspects. Maybe in engineering or maybe in, medicine or everything. It's not just, only IPR. IPR, yes, when we are discussing with IPR, when we talk about one example which I gave in this presentation was jurisdiction for filing a case. If theoretically you say, every lawyer will say, you go to section 20 CPC and file a case. But if you teach them practical aspects, you will tell them that in Copyright Act and the Trademarks Act, there are exceptions of section 20, and there are additional places where you can file an infringement case. So such kind of practical aspects are need to be taught to students so they know which you can also take help from moot courts. Like you devise a problems, a real problem, maybe a problem which has actually happened in court and there is a judgment given by a court. Let's say a software patents or on a business method patents. Everyone knows software patent are exception under section 3K, they cannot be patented. But there are certain cases wherein which Delhi High Court has allowed softwares to be patented. So they have given guidelines. Okay, fine. If you can find these all things in your invention or patent, it can be patented. Even if it is software, doesn't matter. So these are the things which need to be taught to students, that apart from theoretical, you need to have a practical experience to look into, and that's how you will be able to help your clients, I must say. Or if you want to become a teacher in future, then you can teach your students how things are done in practical field.
Thank you so much, Ayush, for your insightful thoughts. It was a pleasure to have you here.
Thank you, ma'am. Thank you so much.
Sorry, Toshi, I would be again intervening. May I request Maksudji to give rights to everybody so that we can have a quick photograph? Maksudji, are you there?
Done, ma'am.
Thank you so much. May I request all the participants to switch on their cameras? It would be a nice thing to have a photograph with our resource person, Mr. Ayush. Please, participants, could you please switch on your cameras? Okay. We'll just wait for a couple of minutes, sir, so that we can get most of them to switch on their cameras. All right, I will be taking a picture. Thank you. Thank you so much.
I would request all the participants to fill the feedback form as soon as possible. We'll be sharing the link on the WhatsApp group, and the link for the session quiz has already been shared.
Thank you,
Thank you.
Ayush. Thank you very much. It was certainly very elaborate, and I think you covered each and every aspect. It's going to help all the participants. And in fact, I do recollect calling you for a workshop along with your partner. We can always think of organizing one more workshop with you in the current semester or whenever time permits.
Sure, I'll be happy
Thank
to.
you very much. Thank you very much for sparing so much of time. Thank
Okay,
you.
thank you, sir. Thank you,
Thank you.
everyone.
Thank you so much. Thank you.